Good morning, everyone. It is the 10th of December, 2021, our last stakeholder meeting of 2021. So next time we see you, it will be a new year. I apologize that my name is Shana Horton. I am the rules attorney. We're here to talk about port of entry rules and public safety rules. I am feeling a little bit under the weather today, so I apologize if I cough. I'll just have to mute myself. Let's see. Looks like we've got 23 participants. Might give people just another minute or two. But just so y'all know, I would like to start with Chapter 39, Port of Entry rules, because I anticipate that those will that will be a shorter discussion, so that those who are only interested in that chapter can sign off once we're done talking about that, and they won't have to wait through the discussion of all of the other chapters for public safety rules. All right, we're up to 27. I'm just going to give it another minute or two. Did anyone else have trouble using the link in the email? Raise your hand if you did. Okay. That's good. Okay, well, we've got 32 participants, so we'll go ahead and get rolling. As I stated before, this is a stakeholder meeting. It's an informal discussion with stakeholders and members of the TABC staff who are subject matter experts regarding some draft rules. The Port of Entry rules, Chapter 39, we anticipate bringing those before the commission at the next commission meeting. However, item 1, the public safety rules, this is the first of 2 stakeholder meetings. So after today's meeting, we'll go back and potentially revise those rules and bring them back to you at our February stakeholder meeting. So those are not planned to be before the commission until the March timeframe. With that said, let's go ahead and get started. We're going to take the items out of order. Again, we're going to start with Chapter 39, Port of Entry. The reason that we are touching this rule is just part of our 4-year review cycle. And we talked with the folks who actually work at our ports of entry and asked them what would be helpful for them in the rules. First and foremost, we needed to revise the only existing rule to allow for the way that receipts for taxes and fees paid are printed these days. We don't use stamps anymore. We use a printed receipt, and we may in the future potentially be able to use the new AIM system for receipts. We don't know. So what we've done is just broaden the types of receipts that we can use. Any written acknowledgement. Pardon me. That is 39.1. And then we talked with the folks at Ports of Entry about what other rules might be helpful for them to have, and decided that we would like to just create a whole chapter that's sort of a one-stop shop for anyone who needs to find the applicable standards. And so what we've done is create some new rules that reflect statutory standards that already exist, as well as practices at the ports of entry that are already what we are using. So calculation of taxes due, again, those come straight from the Alcoholic Beverage Code, but we just want them to be easy to find here in the rules. Then 39.3, assessment of administrative fees. So we have a separate rule for the administrative fee. And then you'll see in subsection 39.3B, this is something that we get lots of questions on is, well, if you're charging a $3 fee per container imported, what counts as a container? And so these standards that are in B here are the standards that have been used to date at ports of entry. So this just makes it clear in the rule to those who are bringing those things over. And then in C, we have a bit of a catch-all for oddly shaped containers where it's unclear how much they hold exactly. Those will be assessed a fee based on an estimation of the volume of the container, just like the others. In 39.4, we have reaffirmed that we will have the table of taxes due posted at ports of entry. They are already posted, but again, that's just for the sake of completeness of the chapter. And 39.5, finally, we have added a rule that will assist our folks at ports of entry when they need to refuse an illicit beverage or something of that nature. This just lays out the types of beverages that can't be imported into Texas for personal consumption and the statutory basis for that. And then it gives the 3 options for how to dispose of any beverages that are disallowed. And that is just hopefully helpful to not only to the people who are bringing alcoholic beverages across, but also to our folks who have to refuse those beverages. They'll have a rule that they can point to that's very clear, and that should help them with that part of their job. So that is the new Chapter 39. And at this time, I will open it up to your questions and comments on any of the rules, either the amendments to the 39.1 or any of the new rules in Chapter 39. If you have a comment or a question, you can just unmute yourself, say your name and who you represent, if that's applicable, and then make your comment. I see Marcus's hand is raised.
Hey, Shana, Marcus Schwartz, Bracken Schwartz PLC. Just one quick question on these, and maybe this generally goes to, well, can you hear me? Shana, can you hear me? Okay. Well, assuming you can hear me, there are importation limits for personal
Marcus,
use.
we're having some technical difficulties. I can see that you're unmuted and you're talking, but I can't hear you, so.
Testing.
Marcus, I can hear you. This is Amy.
Okay, I have it now.
Okay, sorry. There are personal importation limits in statute, and some of these calculations of taxes, I guess they're just dependent, you say like 42-gallon barrel of malt beverages when your personal importation is a case. Is there a reason for that? Or is that meant to capture the one exception where you can import a personal collection if you do it through a motor carrier?
I am going to let John Rainey respond to that question. If he is on. Okay, I'm not hearing him. I actually don't recall why it's a 42-gallon barrel. I know that I was trying to do each one by per gallon, just for the sake of consistency. Obviously, we're not changing anything about the personal importation limit. That's statutory. So I will have to get back to you on that.
No problem. It's 10707, just FYI, on the importation limits for personal use.
Okay. Anyone else have questions or comments about any of the rules in Chapter 39? And again, we anticipate proposal at the January commission meeting. Tyler.
Hi, good morning. Tyler Rudd
Morning.
with the Wine Institute. And I think I've already answered this question personally, but I want to make sure that none of this applies to people who have a collection of wine or spirits or beer that they're moving into this state. This is only for the personal importation from a foreign country.
Right.
Okay, thank you.
Okay. Anyone else on Chapter 39? I should mention, if you don't wish to speak, you can use the chat function. I can see that and read your message aloud. Okay, I'm not seeing any other raised hands. If you do think of something later, as always, you can email me rules@tabc.texas.gov or shana.horton@tabc.texas.gov, and you're also welcome to call me. We want to get this in the best shape possible before we go to proposals. So please do reach out if you come across something that you want to comment on. Sooner the better. Okay, with that, we will move back to item 1, which is the review and revision of the chapters of our rules that relate to public safety violations as opposed to administrative type violations. Again, this was part of the 4-year rule review. It was time to take another look at this and improve it. And I think one of the major changes is obviously is in the schedule of sanctions and penalties for health, safety, and welfare violations. We have proposed a new chart that mirrors the one that we recently adopted for the administrative violations. So it has the same kind of structure. And you can see that the one that's grayed out on your red line draft is the prior, which would be repealed. And then below that is the one that we are proposing that says description, code section, first, second, and third violation. We'll start with general provisions. In 34.1, we have added definitions that we actually have pulled up from other sort of random places, not random, but various places in the rules. It made more sense for those to all be consolidated in one spot. And so we have, pardon me, definitions of assist, which is an existing definition that we've just moved up. We've defined the code, lewd and vulgar entertainment or acts, narcotics, and we've defined written to include all kinds of writing. And again, that's to facilitate the use of AIMS, however it may be used, if there is some kind of a communication through that portal or any other written transmission. Pardon me. We have in subsection B, simply, we're not changing anything here, just sort of simplifying it. Authorized commission personnel can settle an administrative action initiated by the commission. That doesn't substantively change anything. It just is a lot fewer words to say the same thing. We have taken out, proposed to take out subsection C, that a settlement must reflect the number of days a permit will be suspended or the amount of a civil penalty authorized in lieu. And one of the reason for that is that there's often a combination of the two. So, you know, the or can be confusing. And so we just felt that that was an unnecessary constraint. On C, for written warnings, we have defined what a written warning is. And it's nothing new. It's just the notice that someone gets that there has, you know, there is a violation, and we've specified that it can be issued by any authorized commission personnel. And then I have added in here that it's counted as a violation for purposes of bond requirements or forfeiture. So when you're counting violations, that a warning does not come with, and this is something that we talked about under when we were talking about the penalty policy last year. A warning does not have an attendant sanction or penalty. However, it does count as a violation. A violation did occur, that there's a notice of violation, a warning is issued. So that for the purposes of bond requirements, having to post a bond or forfeiting bond, that's going to count. And I just wanted to make that clear in this section on written warnings. I think there's some confusion about written warnings, so hopefully this will help clarify.
Shayna,
Let's just talk about those.
Or are you going through the whole rule?
34.1 A, B, and C. If you have a comment, again, just unmute yourself, say your name, who you represent, and go for it. Like, we've got several people unmuted, so let's start with Amy Harrison.
Good morning. Thank you. I'm specifically looking to see with the written warnings. People in the common world, when you hear a warning, they think about probably they're speeding. At least I get a lot of those. And when you get a warning, that's just what it is, a warning. It's not a violation. You've been warned, and you go on down the road and you don't have to talk to or meet with anybody. If you're going to make a warning an actual violation that's going to be used to determine bonds and their forfeiture, why are they even called warnings? Just write them a violation. What's the point in having a warning? And I'm using air quotes, if it's treated as a violation. And warnings are quite subjective from an agent's perspective. I'm going to give you a verbal warning today versus I'm going to give you a written warning today. And I can't see where the commission's ever posted any kind of guidelines to the public so that you know what the difference is and why some people might get a verbal warning versus a written warning. So I disagree with warnings. I think warnings ought to be warnings. And if they're not warnings, then they ought to be a violation so that people in the public have a clear understanding that they have been cited and that they need to take action to defend themselves. So that's my comments. And the fact that it's used as a bond forfeiture, I think is really unfair to the public and to the permit holders. So I'll let somebody else say what they think. Thank you.
Thank you. Dewey Bracken?
Hi, Shana. Dewey Bracken here. Yeah, I would echo what Amy says. I think it's a misnomer to call it a warning if, one, you do have the right to adjudicate it. But, what client's going to pay to go to court on a warning when there's no fine assessed or suspension assessed? But you're going to force people to go to court on warnings, which appear to be, in most cases, a minor thing that just needs to be fixed. Hey, put your sign up, or you have a stamp off one bottle, but all the other 1,000 bottles have stamps, stuff like that. Well, now if that business could rack up 3 warnings on one inspection, right? You didn't have a sign up, you didn't have one stamp, you didn't have one other little ticky-tack thing, and now all of a sudden I'm losing my $5,000 bond and I have to pay to go to court to fight that. I think those are maybe some unintended consequences. I think it also kind of is counteractive to the commission's policy, that came out in 2017, that it was going to be a warning-based system for regulatory enforcement. So, that's great. I think that's a great policy. I think people get tickets for a lot of things that they probably shouldn't get tickets for, especially in the regulatory area that might be, counterintuitive, or people that are new to the business don't understand some of these rules. So I think warnings are a great thing. And I think the commission's been good to focus on warnings, but when you're going to turn around and say, okay, this counts against your bond, this can be litigated, it's not a warning anymore, right? You might as well just call it a violation and give the guy a ticket and let him fight it in court. So I just think you guys should consider that moving forward. And quite frankly, I would suggest that you don't litigate a warning, right? You get a traffic ticket from a DPS trooper because you're going 75 in the 65. They write you a ticket and you go on your way, right? You might keep a record of it, which I'm sure the commission will. And I could understand, having it used for enhancement purposes in the future, right? Hey, I'm giving you a warning for this sale to minor. I gave you a verbal warning last time. Now I'm giving you a written warning. Now you got another sale to minor. Okay, I'm going to go in the higher penalty range on this one that I'm going to put a case on you on, because you've already got one oral and one verbal warning. I could understand that logic, but to just have them count against your bond and be used for enhancement purposes, I just think that's counterintuitive to the commission's September 5th, 2017 policy. So please consider that.
Pardon me. Edgar, you're up.
All right, thanks, Shana. Edgar Korsanowski with Griffith and Hughes PLLC. I want to echo some of the comments that Dewey and Amy had made. I also wanted to raise some additional concerns. First, how the warning system is actually implemented and used in the field. If the warning is essentially a passive mechanism, here's your citation, good luck, that's the end of the case. Well, you have a due process consideration because unlike your regular violations, which have a suspension or cancellation, you get a notice that says you're giving up your right to a hearing, that there may be a consequence to your bond. And so if you have an unwary or unsuspecting permittee, they'll go, okay, it's a warning, no big deal. Next thing you know, there could be serious consequences. And let me give an illustration. So suppose you have a restaurant with a wine and malt beverage permit in Dallas County, and they have to hold a performance bond. They have 2 prior bond forfeitures, and you issue an outdoor warning violation. Well, at that point, their performance bond is not only revoked, it's the cancellation of the permit. It's a death penalty. And so if you don't have sufficient notice of what those consequences are, this system is incredibly punitive, especially in light of the current economic times and devastation from the COVID-19 pandemic. So I just want to put that out there.
Okay, I wanted to ask one of our subject matter experts to talk about what is on the actual written warning as far as notice of the rights that the person receiving the warning has. So is Major Carla Thompson, our Deputy Chief Ron Swinson, are either of you
Good morning,
on the
Shannon.
line? Okay.
It's Carla Thompson, Major in Houston. The administrative notice for a warning is the same as for a case. So basically it has the same information. It really doesn't give them a warning about their bond. It only states you are being issued a warning for the violations listed below. And then it has a free form.
Okay. And so I'm also reading in my messages that the boxes on the notice are warning versus administrative case.
Correct.
Okay. That's helpful.
Hey, Shana, Dewey, hey, on that note, right, there's nothing when you get the little administrative ticket from the enforcement guys. There's nothing that says you can appeal this, you have a right to appeal this, this will count against your bond, right? So again, if your mom and pop are not sophisticated and somebody gives you a warning, you're going to think it's like when the DPS trooper gives you a warning for speeding and you put it in your back pocket and go on down the road. So I think if you're going to institute this rule as it is, without making the changes suggested, then consider tweaking these tickets to provide people notice that, hey, you can adjudicate this and this will count against your bond.
Yeah, that's kind of where I was going at that last question. And what I want to ask y'all, those of you who have commented, if the applicability to the bonding requirements and forfeiture, if that C2 was removed, would you have remaining concerns?
Edgar here, I would, and the reason is when you're giving out the hearing right, I think that needs to be an affirmative act, much like we do with suspensions and cancellations. From my perspective, I think this is infirm just to issue a warning and then say that this is a consequence without an affirmative agreement from the permittee or licensee.
Hey, Shana, this is Dexter here.
Yes.
Just adding a comment to your question. In terms, like from the auditing side of it, when we issue a written warning notice, and we do that, like Carla's saying, on the ticket itself, but in addition to that, there are some violations where we send out a written notice via letter. In that letter, it does state in there the violator's right to appeal that. However, it doesn't make mention about the bond on the notice, but it does make a mention there in terms of their right to appellate.
This is
Okay,
Amy.
thank
You know, Dexter, I think that there has been a discussion, quite a long history within the agency about written warnings versus verbal warnings. And one of the things that I will tell you that we knew inside, and now I can definitely say from my perspective on the outside, is that there is very little consistency in how some of these things are determined. And if a written warning is going to have consequences versus a verbal warning, one of the things that I would ask again is, how is that determination made? And what factors is an agent or a commission employee given now to make a determination between a verbal warning and a written warning that has consequences to it? And shouldn't the public know the difference in those things and what those consequences are? So again, I just feel very strongly about the fact of warning ought to be a warning. And if it's not a warning, then it should be like everything else.
Hey, Shayna, Dewey again, just for FYI, when you get to your email, I just sent you an exemplar of what that ticket looks like.
Thank you. And it's been pointed out to me that the only substantive change here is the bonding is C2, because 34.1 currently includes a right to request a hearing to appeal and written notice, and that a warning can be used as an aggravating factor. That's been the rule for more than a decade.
But it's never been on any document given to the public when they're issued a citation or violation, except for those few letters that Dexter sent out for audit.
That's a good comment, and then we're definitely going to have to look at whether we need to enhance those tickets so that they give more information.
How many tickets or warnings were issued in the last FY that resulted in a hearing? Does anybody know that?
How do you go about seeking it? Because they don't send you anything. Hey, this is going to be set right here. You just get it.
Can you repeat that question?
How do we know how many actual written warnings have been issued in the last FY that actually resulted in hearings or a request for administrative hearing?
I don't have that information, but I can find out and get back to you. Our general counsel can't recall any in the last fiscal year.
I mean, just Shayna, this is Dewey, just anecdotally, I don't know if there's other guys that do the enforcement cases, but I can't think of one that I've gone to court on ever to fight a warning. And primarily because it's never counted against your bond, right? It's not, the juice isn't worth the squeeze for a client to go fight a warning. But if it's going to start counting against your bond, you're probably going to see more litigation because people are going to try to preserve their bonds, especially in those areas that Edgar mentioned in Houston and Dallas, where you have your performance bond that you get revoked after one strike.
Yeah, I'm hearing you on that. I understand that concern. I also understand the concern with calling it a warning and having it being basically put on your record. Feels people might be confused by that, general public. And, you know, coming into the agency from the outside, I found it confusing as well, but it's the way that the agency has been using that term for a very long time. And so what we're trying to do with this rule is, and potentially with some changes to that warning form, is to sort of find that sweet spot where I'm not telling, you know, all of our agents that they have to completely change the way that they operate and what they call warnings and violations and all that sort of thing. But at the same time, we're making it a little bit clearer to the public, to the regulated community, what a written warning really means. So it's just kind of a little bit of a balancing act, because I do understand that, you know, calling something a written warning could be confusing if people are thinking of other types of written warnings that they might receive from other agencies or entities. So that's the goal here with this revision of this section, is to try to make it clear what it is and what it means, even still using the same terminology that we've always used.
And Shana, I just want to add one quick comment. I mean, the agency does go through with this rule. I mean, really, from our perspective, the main thing is if the warning is treated in the same fashion, the same dignity and process as with the suspensions and cancellations, i.e. you go into a settlement conference and sign it.
Wish to comment on 34.1 through subsection C? Okay. The remainder of the section, there's a lot of changes, so it's not going to be something that I can really go through point by point. Rather, I think I will just, I know that first one I wanted to go through, but I will just open up for your comments on the rest of Rule 34.1. Let's see. The last few, pardon me, the last few subsections there pertain to how the schedule of sanctions in section 34.2 should be used by people entering, agents and TABC personnel entering into settlement. So I want to make sure y'all take a close look at that. Comments and questions about the remainder of 34.1.
Shana, Marcus Schwartz here, Reagan Schwartz PLC. Subsection F, you talk about next hire.
Oh, there you are.
Oh,
sorry. Can you repeat what you just said?
Sure. Marcus Schwartz, Reagan Schwartz PLC. Section F, when you talk about subsequent violations being subject to the next higher level, I'd note out, because you broke out health and safety versus regulatory, your regulatories don't have first violation, second violation, third violations. They're just, you violate it, here's the penalty amount. So to say there's a next higher violation is, I don't think it works well. If you look at, for instance, it's the interplay with 3410. If you look at that chart, there's no higher violations. It's just, if you violate it, here's this. I get the need for, or possibility for, you might enhance the penalty upon a second, but there's no listed higher violation level.
Yes, I understand your comment, and I will look at how I can revise that to make it clearer. Because I think what we're saying is if you have a regulatory violation in that highest category, most egregious category, then when you have a subsequent, well, it's the same provision or rule. When you have a subsequent one, we will enhance it. So that's what I will do to fix that.
Thank you.
Other comments on the rest of 34.1? Okay. Excuse me. Can you scroll down to 34.2 now? Okay, this is the biggie, of course. And what we've tried to do here is just take a comprehensive look at the figure that exists in Rule 34.2 and how we can improve it and make it more complete. And we decided that we thought the best way to do that was to make it look similar to the administrative penalties chart, but keeping the first, second, and third violation split that everyone is familiar with. We've also laid out at the beginning 34.2 B, C, D, and E. There's nothing in those sections that is new. However, these principles were kind of buried in different places, and we felt that sometimes administrative judges and other folks didn't understand or didn't see those things about how we intend for that chart to be used, and assume that the chart is a hard and fast list of the sanction that shall be assessed, and that they have to use it and can't deviate. And of course, that's not the case. It's the purpose of the chart is as a guideline for settlement. Once you get beyond that into contested cases, there's no requirement to stick to the suggestions in the guidelines in the chart. We also, of course, want to make sure to say that the list of violations is non-exclusive. Just because something's not in the chart doesn't mean that there's no penalty for it. It just means that perhaps it's one of those violations that the penalties are going to vary, and too much to put it in a chart. Excuse me. For example, place and manner violations, which we've actually are going to talk about a little bit more later, don't really lend themselves to being charted. So those will be, based on facts and circumstances. Again, we've reiterated that these are used as a guideline. Adherence is not required once there is an Administrative Procedure Act case. Once the case has been referred to legal services, they don't have to abide by this chart. And of course, this chart doesn't have cancellation or suspension mentioned in it, but that doesn't mean that we can't cancel or suspend a license or permit. It's just simply always, pursuant to statute, it's always going to remain a possibility, and it just doesn't need to be put into a chart. So with that, let's get going on 34.2, and please raise your hand. And we will start with, I have water. It's just, it's bronchitis. I'm sorry. I'm very sorry. If you have does anyone have any comments on the overall concept of the chart, the way it's laid out? or anything specific. I see that Marcus Schwartz is unmuted. Please go ahead, sir. I can't.
Sorry, can you hear me? Shayna, can you hear me?
Mr. Schwartz.
Can you hear me, Shayna? I hear that others can hear me, but I'm not sure if you hear me.
Okay, now I can hear you. Barely.
Okay, perfect. On the failure to timely provide records, is there a standard time period for that? The reason I say that is in the past, I've seen agents give, okay, you got 5 days and it's right before a holidays, or others that are 14 days or what have you. And I was just wondering if there's going to be a standardized time for that.
I'm sorry, I really missed about the first half of that question because my earpiece wasn't working.
No
Can you
problem.
just
On
quickly repeat it?
the failure to timely provide records, is there a
Yes.
standard time period for that that the agency is going to consider?
No. So the way it's going to work, the way it's pretty much always worked, is, when you're working with the agency, they're going to tell you, we need these documents and give you, give them to us within the next 10 days or whatever it is that you're discussing with that staff member. And so it will vary based on the circumstances. And then of course, if you call them and say, hey, we couldn't get it done by then, can we have another few days? Can we have another week? And the staff member you're working with says, yeah, sure, that's no problem. Well, now, that's being timely is simply responding to the deadlines that you're being given in your particular case by the person that you're working with. And that we don't want to make it a hard and fast rule because of course there's going to be lots of reasons that you might need more time to gather up a document or find something that that the agency has requested.
Thank you.
And I wouldn't anticipate that being used unless someone is blatantly, flouting requests or ignoring requests for information. Okay, I can't believe that that's the only question or comment about 34.2.
Shayna,
Okay,
this is
Ms. Harrison.
in C, and this just goes back again to the whole written warning thing. In 3, when a record of past violations, depending on what the agency decides to do with warnings, I would suggest that the license and permittee's record of past violations and written warnings be added to that phrase. Just so that it's very clear that even warnings are going to be held in their record to be determined for their penalty. Thanks.
Okay. Mr. Bracken.
Hey, Shayna, I would just, this is not, I'm trying to find the exact section. There's like a catch-all in the rule. I'm trying to find it. I'm sorry, it's escaping me. But it basically says, here's this laundry list of, this is more the 3403, 34.3. I don't know if you want to wait or jump into that
No,
now.
sure, go ahead.
There's this catch-all, I think it's 34.317, where it talks about any other violation that we say, basically. And a little history, at least from my perspective, on this whole rule. my recollection is this was passed originally because the Wishnow case, Wishnow v. State, I can get you the site, but it was a Texas Criminal Appeals Supreme Court case en banc, where they basically found the, offensive to the public decency and some of that place or manner verbiage to be unconstitutionally vague. And this rule, to my recollection, was an attempt to kind of cure that statute that the courts found to be unconstitutional by giving permittees notice of what type of behavior is allowed and what type of behavior isn't allowed, which, you could argue that and litigate it, whether the rule cures the unconstitutional statute or not. But I mean, nobody's done that yet. But and this is nothing new. This subsection 17 has been there. But I do think when you have something that says any other law or rule that we say that we determine to be violative, to paraphrase, and I've had legal throw that section out on us before at hearings, right? I think you're just going to make that subject to constitutional challenge, because I don't think 17 sub 17 gives any of our permittees notice of what they can and can't do, unlike these other sections. So I get this is kind of the kitchen sink statute, and that's how it's used. And I think the rule is good to try to save that statute if it is subject to a constitutional challenge. But if the agency is going to go under this sub 17, you're just right back to the holding in the Wishnow case.
Okay, if you wouldn't mind sending me that citation,
Sure.
I'll take a look at it and see if there's any way to improve on the language in 17 to provide better notice of what we consider detrimental to general health, welfare, peace, safety, etc.
Will do.
Thank you. Mr. Schwartz.
While we're on that subsection, the place or manner, can you speak to why the inclusion of drink solicitation, which is its own violation, into the place or manner, why that one specifically?
So that was added as a result of something that happened in a legislative session. Can either of my subject matter experts comment on that? Or Terry?
This is Ron. Ron Swenson with TABC. I don't recall the exact specifics, but it was added as its own section because we know that it can be used as a precursor to human trafficking. So they strengthened the drink solicitation section. Chief Jones might remember more of the details exactly. It was 3 sessions ago, maybe, when it was added and broken out separately. Or Terry Hamby might remember more of the specifics, but it's because of its close ties to human trafficking.
Yeah, I missed the question. So I don't know, Marcus, if you want to repeat it.
Sure. I was just wondering why the inclusion of drink solicitation, which is its own offense, into place or manner.
Yeah, Run basically hit the nail on the head there. It was added a few sessions ago as a precursor to human trafficking. We found that there was a connection there. And so legislature added that into the rule, into the law, I mean. I'm not sure if that answers your question or not, but that's the reason why it was added there.
Understood. I'll look into it. And
Okay.
if I have any comments, I'll get back with Shane on it. Thank you.
Sounds good.
Other comments on 34.3 or 2? So the purpose of 34.3 is obviously, those aren't in the chart. So we want to tell you how we're going to handle those to the greatest extent we can, because they are so various. Marcus, is your hand still up? No. Okay. All right. Let's go ahead and move down to 34.4, suspensions. Are there any comments and questions about 34.4? Because then we're going to take a little bit of a jump to the regulatory sanctions. And Marianne, can you remind me, are we set just for an hour?
I believe it's an hour and a half, so we have 30 minutes to get through the rest of them.
Okay. I'm not seeing any hands on 34.4 suspensions. So we'll move on down to 34.10. And so we've moved the sanctions for regulatory violations down below and a few rule sections away from the health and safety violations, just to kind of give a signal of the difference. Are there any comments and questions about 34.10? And to the extent that you all have identified over the past year or so any problems or confusing parts of the chart that we adopted, now is the time to bring that up so that we can fix it and make it clearer or more accurate.
Shana, this is Edgar from Griffith and Hughes. I had several comments regarding 3410, if that's okay.
Mm-hmm.
So our principal contention is 3410A. It talks about the augmenting and discounting of penalties. At the time, the date of notice or the notice of violation was issued, as opposed to the time of the commission of the offense. From our perspective, this seems to be an ex post facto issue. I know not everybody's a lawyer on that, but basically, the Texas state constitution, U.S. constitutions prohibit retroactive penalties or punishments that are greater, or increased punishments that are greater. And this is what it looks like. And I'll just give some examples of where this could actually come up. So, for example, prior to March 1st of 2021, I can just give you how this might look. So prior to March 1st of 2021, permitting consumption of beer off premise at a location, $1,500 maximum penalty for a first time offense. Whereas here under the new rule, which I don't know if it's really that new, but it started March 2nd, if I'm not mistaken, $6,000 maximum penalty. And this is not including any kind of economic benefit to the permittee or licensee. Same thing, sale to respondent on a delinquent list under the old rule, 1,500, and under the new rule, 6,000. And storage of alcohol, 1,500 under the old rule, and it's 6,000 under the new rule. And here you have what's arguably a public safety violation that's snuck in there, place or manner over serving, which is closely related to sale to an intoxicated person. Under the old rule, it's $3,600 for a first time offense, whereas here it's 6,000. And so again, this isn't a hypothetical, this is a very real possibility if TABC doesn't timely prosecute or get to a violation and go, well, we're under the new rule now, so we're issuing the ticket today, and these are the new rules. Well, okay, so the client is already hurt here. But let's just say a few years down the line, TABC says, you know what, I really don't like those outdoor sign violations. They're really hacking me off. They're $5,000. We went and did an audit and found that they didn't post the sign, a few weeks back. Yeah, it happened before the new rule came into place, but hey, we've got this rule. It says we can do it. So I think there's some issues with that rule for that reason.
I understand your concern. It should be the date of the offense, not the date of the issuance of the notice of violation. Is
correct.
If I'm boiling it down correctly. Anything else on 34.10? Okay. 34.20, all we've done here is move the safe harbor rule down to the bottom here. As you all know, we are working on that right now in a separate rulemaking. So we're not touching it in this one. And likewise with 34.21, 22, just moving those down. So that's chapter 34. Any other comments or questions on chapter 34 before we move on?
Sheena, this is Edgar from Griffith and Hughes. I just wanted to put a brief pitch out there for the agency to consider implementing statute of limitations for violations, as well as timelines for making licensing decisions and disposition of cases. I can't talk about specific cases where we represent a client, but I can say this, that we have experienced considerable delays in decisions and also prosecution and disposition of those cases. And I think if the commission were to consider drafting some rules that address timelines, it would be really nice. You do have statute of limitations in criminal cases and civil cases. Those are really helpful for preserving the agency's goals of timely enforcing the code, and also the due process concerns of people that have permits, because memories fade over time, records may become lost, and of course witnesses can't be found. I did submit a written comment, so I'm not going to go over that. I also submitted a proposed rule, so it's just something for the commission to consider. Thank you.
Anyone else on chapter 34?
Hey, hi, Shana Dewey here. Yeah, I would echo what Edgar says. I think I realize none of these, there's no statutory statute of limitations in the code. There never has been. I do think it would just be a good public policy to say, and pick a date, 2 years, 3 years, 4 years. Most criminal statute of limitations are 2 to 4 years. Certainly most civil liabilities, 2 years. But I mean, I have a handful of cases that are being investigated now that occurred 3 years ago. And, odds are if they ever get to a hearing, it's going to be 4 or 5 years after the date of occurrence. So, witnesses leave. It's harder for the commission to try cases. It's harder for permittees to defend cases when you're going back to things that are that old. So I think it's a good idea from a public policy standpoint to pick a date. Thanks.
Yes, and obviously for our folks that are trying these cases, it's in their interest to get it done sooner so that we have fresh memories and documents don't get lost. I do have some concern that we probably wouldn't make such a substantive provision in rule without any direction from the legislature. I don't know that for a fact, but it would be a big thing for us to do sua sponte.
Shana, this is Edgar. I would note that that at least one administrative agency has done this. It's the Texas Appraisal Board. They do have a rule, and again, I've cited that in my materials. I think it's 22 Text Admin Code 15320. I think certainly the commission has the authority to do it under 5.31 of the code to ensure consistent, predictable, and timely enforcement of the code. So it's just a matter of what I call it will rather than a prohibition. So I'll leave it at that.
Vanessa Harden, you're unmuted. Okay. Thank you. Okay, with chapter 35 enforcement, we've really just kind of rearranged and reorganized, moved some offenses into different places because they don't really make sense in this chapter. Again, 3521, it's just defined that we move that up to the definitions section. Offenses against the general welfare, we move that one up just below the sanctions chart for health and safety violations. This bottle capping devices rule 3511, it's in a weird spot, and so we're planning to move it adjacent or very close to the rule that allows for can sealers and that sort of thing. It's the purpose of the rule. It's that you can't have something to seal for unlawful purposes. For example, refilling bottles and that sort of thing. So it's still a good rule. But we think it needs to be juxtaposed with the lawful reasons for which you could have a device used for capping and recapping. But we can't do that with this particular rulemaking because that chapter is currently open. So we're going to have to do that at a later date. And so that will disappear, and this chapter will simply just be simplified. Any comments or questions on chapter 35? And now chapter 36, again, this was just one rule.
Shayna,
Yes, go ahead.
sorry, Marcus. One question on the breach of peace reporting. I know you've added in B, if a shooting, stabbing, something bad happens on the licensed premises or on premises under control or the licensee or permittee. You didn't use exclusive control, so I'm guessing just anything partially under their control. I'm thinking like common areas, right?
Right, and I'm trying to remember the discussion surrounding this. Does anyone from enforcement who is on the line recall the reasoning?
This is Ron Swenson. I don't recall common areas, parking lots that share multiple bars sharing a common parking lot. We would have to determine where it originated from to get a successful case on that. But adding the word exclusive control might not be a bad idea, just to cement that in. Shanna, we can talk about it afterwards.
Okay.
This is Edgar. I think I know where this is coming from. I'm guessing it's from the definition of premises under 1149. It's to basically firm up or clear up any gap. Is that fair to say?
That's a good guess as to where we were going with that.
And I just mentioned in subsection G then, which has to do with when you've got to report law enforcement, it's not consistent with B in that you're only using the licensed premises.
Okay.
If you check this 2811, it just mentions control. It does not say exclusive control.
I get that. So in the situation where bars, share a parking lot, say there's 5 bars, there's plenty of areas in Austin where there's a multitude of bars that share a parking lot. The way this reads now, then all 5 of those bars have to report the breach. I don't think that would be intended.
This is Edgar. Again, I think it would be helpful maybe to define control or have some sort of general understanding, maybe not necessarily exclusive factors. So it addresses the issue, whether you're looking at 1149 or 2810 or the permitting or the breach reporting statute, because that's always a point of contention. Again, if you're having multiple businesses sharing the parking lot, or what about a public roadway, right? It's right across the location. Is there an obligation to go and report a shooting that's right there, even though you don't actually control it?
It would be helpful to me if you have encountered some problems with the interpretation of control in specific cases. If you could please let me know, send me an email or give me a call. That would help me determine how to tighten up that language to avoid those concerns. Okay. Let's move down to the possession and sale of firearms on licensed premises. There are some clarifications in that rule, and I want to make sure that we talk about them. Excuse me. Marcus, your hand is up.
Oh, sorry, didn't mean it to be. Take it down.
Okay. Does anyone have concerns about the clarifications to the gun regulation? Okay, very good. In chapter 37, legal, we just removed the subchapter headings, and we moved the suspensions rule up to chapter 34, as you'll recall. Although this chapter doesn't contain a lot of rules right now, we would like to keep it because we feel that there is a potential in the future to fill this out a little bit more if we need to adopt rules related to motion practice or something like that. So we're going to leave it here, and that way we'll leave that avenue open in the future. And that is the end of our document. So at this time, we have 13 minutes left, and I would open it up to comments and questions about any rule, chapters 34 through 37.
Shana, this is Amy. My comments are not really specific to the rules, except for that the rules sometimes refer to legal, being referred to legal. But if you go to the agency's webpage and you look at organizational charts and the such, you don't ever see a legal division. And so that may be something that wants to be addressed. If you're going to have a whole section on a rule, you know, who is legal and what does that look like on an organizational chart? I think all of us probably know, but for outsiders, it might be good to have that be more clear on the webpage. And then as we discuss these rules, and you mentioned the future use of aims, I would just say that, you know, I think it probably is clearly understood at this point that if aims is used in the future for any type of these reportings and rules, we would ask that there be some public beta testing and that we be more involved in that activity than we as a public and as a group of people that are involved in trying to help the public in alcohol regulation be included in those discussions for how aims is used, just knowing what kind of situation we're all dealing with right now as a result of aims. So thank you for today, and thank you all for all being there.
And I think the commission recognized that, and for that reason has proposed the subcommittee on major technological projects and implementation that will provide an avenue for more input from stakeholders. Anyone else on any of the rules? And again, we're going to talk about this one more time, at least in February. So as you have identify comments and concerns, please get them to me sooner the better. But keep in mind that you'll have another opportunity to speak with the agency in February. It looks like we don't have any further comments or questions. So with that, give you back a few minutes of your time. And thank you all so much for your participation today. It's always very helpful. And as always, please don't hesitate to reach out at any time at shana.horton@tabc.texas.gov or at rules@tabc.texas.gov. And all of your input is very helpful and appreciated. Everyone, please enjoy the rest of your Friday.